Thank you, and thank you everyone for joining us today. We are talking about tailor-made wills. So really what we're talking about here is what are the different provisions that can go into a will to suit the different circumstances that everybody has in their own life and their own family structure and the type of assets they have. Briefly, before I go into that, I just want to remind everybody what a will is and what the process is for that will to be followed. So a will is a statement of your wishes. Each will you sign is your last will and testament, meaning it invalidates any prior document, and this is your last one. When a will is, upon someone's death, when a will is brought to the court for what we call the probate process, that's the process by which that will is deemed to be valid, hopefully, or invalid. But if it is deemed to be valid, then the court will also determine if the executor who is nominated under the will is an appropriate person to be executor, and then the court will appoint that person. So I point this out because it's very important to remember that what you put into your will is a statement of your wishes. And until that will goes through that probate process and the executor is appointed, you don't have a final answer on what's going to happen. Now, that doesn't mean that when someone's appointed as executor, they can change the terms of your will and who to distribute assets to. Once that will is deemed valid, that is what will be followed. And so what I'm going to be talking about is what are some things that we put into this document that makes it important to have, and also different from what would happen if you died and you didn't have a will. If you die and you don't have a will, we call that intestacy. So that's when you die intestate, meaning without a will. And then there are certain default rules as to who will get your assets. Now, when I talk about probate and when I talk about who gets your assets in intestacy, in all cases, both of those cases, I'm referring to assets that are in your sole name with no beneficiary. So remember, if you have a beneficiary named on an asset or something is joint with rights of survivorship, that will go to the person named on the account or on the piece of property. But this is for assets in your sole name. So let's say that I pass away and I own an apartment and I own a checking account and I own a retirement account, but I've named a beneficiary. When we talk about probate or intestacy, we're talking about where that apartment's going to go. And we're also talking about where that bank account is going to go. We're not talking about my IRA because I've named a beneficiary there. So I just wanted to explain that as an underlying or underpinning concept of everything that we're going to talk about today. If you do have a will, like I said, you are going to nominate an executor. Now, that can be something that is contested at the time that your will goes through probate. Maybe you've named, I'll give an example of a case that I actually had years ago. One daughter was named as power of attorney. She was also named as executor in the will. And her sister believed that while she was serving as power of attorney, she was stealing assets from mom. And so when it came time for the will to be probated, the sister who was not named didn't contest the terms of the document in terms of where things would be distributed. But what she contested in the surrogate's court was that her sister shouldn't be appointed as the executor under that will because her sister had been stealing while mom was alive. And then there was a long drawn out hearing process and everything that goes through the probate process when somebody's contesting. And again, not to say that that will was invalid, but to say that that executor was not an appropriate person to be named as executor. So you would nominate an executor. You could nominate a guardian for any of your children who may require one. So if your children are under 18 at the time that you die and there is no legal guardian or legal parent, your will document can state your preference for who will be guardian. And again, that's strongly followed by the courts, but if there is somebody contesting because of something that maybe you didn't know when you were writing your document or some other reason they think this is an inappropriate person to be named, that's what's going to be taken into consideration. Your will can also appoint trustees, and I'm going to get into the different types of trusts that you might put into your will document. But the trustees that are appointed or nominated by you in your will are ones that will oversee the trusts that are created through the probate of your will. And I'm going to get into that in a minute. Your will can also give specific bequests. Now, what does this mean? This means giving a specific item or a specific dollar amount. So I may say I give my favorite diamond pendant to my sister. It may say I give my all of my jewelry to my children. It may say I give my apartment to one specific person, or it may give any other dollar item. So I give $5,000 to each of my living grandchildren, perhaps, or $2,000 to my best friend, $10,000 to my favorite charity. These are specific bequests because they are specific items or specific sums that are being given out. Once the specific bequests are listed, there is then the residuary. One more thing I want to say about specific bequests is that's very important is when you're creating a will, the will can't talk about any documents other than what's written in that will. So what do I mean by that? Somebody who does other planning, a trust planning or something like that, that isn't the subject of today's webinar, they may have a section that says, I'm going to do a memorandum, and every time I sign and date a memorandum, that's going to be the one that controls, and it's going to say where all my items go. And I may give one set of earrings to one person, another set of earrings to another, a bracelet to a third, and I go through. A last will and testament legally cannot incorporate a separate document like that. So if you have very specific wishes regarding where items are going to go, you're going to want to put that in your last will and testament document, if that's the planning that you're doing, to make sure that that is a legally binding bequest that is carried out by your executor. Other than the specific bequests of tangible property or of monetary amounts, there's then the residuary. The residuary is usually either broken up into fractional shares or percentages. So for example, I may say I give these specific items to specific people, but then the residuary or the remainder of my estate should be distributed 1/3 to each of my 3 children, or 20% to one child and 40% to each of my other 2 children, or however you decide to break it out. There could be charities involved in the percentages, whatever it is. You're also going to want to make sure that for each person you're naming, whether it's for a specific bequest or for part of the residuary, you say what happens if that person predeceases you. So when I sit with a client, I'm always saying, well, then what, then what, then what? So you leave everything to your daughter, that's great, 100% to your daughter, but what if your daughter predeceases you, then where does it go? You can say that if you have, I leave everything 50-50 to my son and daughter, you can say that if one predeceases you, the share goes to the other person. You could say if one of them predeceases you, that share goes to their children. You can say anything you want as to where that share would go, but it's important that it be discussed in your document so that there isn't an ambiguity or a confusion when the time comes to probate your will, if one of these people does predecease you, or if one of your charities doesn't exist anymore at the time that you died. A lot of our documents are going to say, for example, I give all of my assets to an animal shelter. And you may pick your favorite animal shelter where you got your dog and you love it and you support their mission. But by the time you die, that animal shelter may not be in existence anymore. So you can say another animal shelter, you can put other items in, or a lot of times for charities we'll say, or if this isn't in existence anymore, then give this amount of money or give this percentage to an organization with a similar mission to that of the one that I chose, and that my executor has the right to choose that. So maybe that animal shelter doesn't exist anymore, but you can choose to give your assets to a different animal shelter that treats the animals in a similar way and has the same attachment to finding them homes or whatever it is that you really loved about that first animal shelter. And so again, specificity in all of these things is going to be the most important. Another item on specificity is some clients come in and they want me to put the name, the address, the phone numbers, all of these things into the last will and testament. Very often we don't do that because those are always subject to change, or it's something where once the will becomes a public record at probate, you might not want that in the document. But in any case, we do want to be as clear about who we're naming as possible. So for example, if you have a daughter named Britt Berner, you would want to say, I give my estate to my daughter, comma, Britt Berner. So you're being very clear that that's who you're giving it to. You know, there are people who through the generations, they reuse family names and things like that, and we just want it to be very obvious as to who we're talking about. So you really want to be clear and specify who it is that you're referring to, that you want to give a certain item to or name to have a certain job within your document. So that covers the bequests, the specific bequests, the residuary. We then will put in a paragraph called the remote contingent beneficiaries. And it's exactly what it sounds like. Who are going to be the beneficiaries on the remote chance that all of the other people that you have named in your document are unable to accept the gift. They're not living, or for some reason they disclaim it, they say they don't want it. Then what? Many people will say, just give it to whoever New York State deems to be my next of kin, because they don't have a specific reason to pick someone. Some people will pick a charity as the taker of last resort. Some people will name a specific distant family member because they know that they have 20 first cousins and they only like 3 of them, and so they want to make sure that those 3 were to receive the bequest if all the other beneficiaries were to fail. So you're going to want to make sure that's in the will document to make sure that things are going to, again, be very clear. We don't want ambiguity where we're trying to guess what the testator was trying to say in their document when we're probating the will and they're not around to tell us what they wanted anymore. It's going to be very important to be specific about these things. Now let's talk about the different trusts you can put in your will. Now, anyone who's seen any of the stuff we put up, you know, sees the picture of our dog Sophie on our pet trust ads to remind people that pet trusts are a thing. You can have a trust for the care and support of your pet or pets after you pass. An important thing to remember is this is going to require that you name a trustee of that trust, and that trustee, they don't just take the money and use it for the pet. It is a formal trust that's created. So that pet is going to have a trust, and that trustee is going to have to open a bank account, take the money from the executor, put the money in the bank account, and use it accordingly. And so it's going to be very important to realize that, because a lot of times people say, I want a pet trust. And when I start to explain that to them, they say, you know what? I would rather just give the dog to my daughter and give her an extra $20,000 and she'll use that to take care of the dog. And that's a lot more informal way of getting the same thing accomplished when you trust the person that you're giving the pet to. Because a lot of people don't want the extra legal structure of creating a trust for the pet. Although some people do, and we do provide for that if it's necessary. There are also charitable trusts, and there's certain tax benefits that I won't delve too far into today, but there's certain tax benefits if you do have a taxable estate. Let's say right now in the federal realm, you can give away $11.58 million with no estate tax consequence. New York State's exemption is $5.85 million. Anything that you give to a valid 501c3 charity, as is determined by the IRS that they are a 501c3 charity, they get that status, that will reduce your taxable estate. So some people will do, for example, a charitable remainder trust that says the charity gets it at the end, but upon my death, there's a beneficiary who receives income from the trust for their lifetime, and then upon their death, it goes to the charity. And there's different options there for those who are charitably inclined and trying to protect against the state taxes and still also protect the individuals that they love and giving income for their lifetime. There are also, in the most simple of wills, you'll usually see a provision that says if anybody's under 18, then the executor can choose to hold their money in trust and distribute it to them when they're 18 years old or when they're 21 or 25, whatever the age is, and that's very simple. A lot of times when we're creating documents for those who are naming minors as beneficiaries, we will create what's called a common pot trust. So I'm going to give you an example. Let's say we have a couple with 3 young children. Their children are 1, 3, and 5 years old. And the couple creates a document that says, upon the death of the second one of us, because one spouse leaves to the other and vice versa, but if we were to both pass either in a common accident or one after another, then the assets will go into a common pot trust for the benefit of our 3 children. And when the youngest of our 3 children hits a stated age, and again, a lot of times people pick 25 for this age or 30 or somewhere in between, and when the youngest child hits 25 years old, then the assets will divide in 3. The idea behind that is that the older children had the benefit of having a mother and a father who provided for them longer than the younger children. And so you want to make sure they're all provided for. You may have a case where the youngest child has not yet gone through college, but the older ones are either finished or almost done. So the younger child has more expenses up front that have already been covered by the parent. You also don't know what needs your child's going to have. Some children have more expensive or greater needs than other children. And so just like 2 parents would be making a decision as to how to allocate their funds for camp for certain children or education or anything else, a trustee can make that decision while the children are young. What we usually do then, once the youngest child hits that stated age, is whatever's left in this common pot trust will be divided 3 ways equally, and each of the 3 children would then have their own trust. They could either be their own trustee immediately, they could have a co-trustee and then be their own trustee later on, or they could have a trustee that continues on and manages the assets for them and distributions to them indefinitely. And those are decisions that can be made in the drafting to determine what's going to happen with that child's share as they get older. These trusts that we separate out to for the 3 children, we commonly call them beneficiary trusts or descendants trusts, but these are trusts that are drafted in a way where that child has all of the income coming to them from the trust assets. They can access principal on their own or with an interested trustee, someone who's related to them for health, education, maintenance, and support. And if they want assets out of the trust for any other reason, they have to appoint what the IRS calls an independent trustee. This is a trustee not related by blood or marriage who could authorize a distribution. If they follow these rules as are stated in the trust document, and again, the trust document in this scenario is in the will of the parents, then the assets in the trust maintain creditor protection and are outside of that child's estate for estate tax purposes. And so it's really great to be able to create this creditor protection for the children that the parents couldn't have created for themselves and that the child couldn't create for themselves, but you can create it when you're stepping it down from one person giving to another. We will often do those types of trusts for clients, not just when the client is a minor, the child is a minor. That is was my example based on it coming from the Common Pot Trust. But a lot of our clients are in their 80s, for example, and they have children in their 50s and 60s, and they want that those adult children have their assets in a trust where they can manage it themselves because they've surpassed the age by which you need to be to manage it yourself. But they have this added creditor protection. And so it's a really great option for people who are worried about making sure that their children aren't going to have issues down the line. We also very often will do a supplemental needs trust for a disabled beneficiary. That is a trust that allows the beneficiary to receive their inheritance in a trust that's protected and managed for them. They cannot be their own trustee, and also be able to get government benefits that have an asset limit or an asset test. And so that's what a supplemental needs trust is going to do. The concept is that it supplements, not supplants, government benefits. So it can't be used for any of the items the government benefits would pay for, but it can be a supplement to that. In almost all of the documents that we create in our office, we put what's called a trigger supplemental needs trust into it. So what we say is that if any of the beneficiaries are on any government benefits at the time of the death of the person who wrote the will, then their share will be shifted into a supplemental needs trust to their benefit. This is a just-in-case catch-all. We had a client who was 102 years old. He died as a resident of a nursing home. And when he died, his assets passed to his son. His son was 80 years old and on Medicaid and living in a nursing facility. So the assets passed into the trigger supplemental needs trust. It was triggered into effect because of these government benefits. And the gentleman was able to stay in the facility, continue to have Medicaid pay for the facility, and have the benefit of this trust to supplement his life, pay for clothing, for television, whatever it is that he needed in addition to his day-to-day needs that were being covered by Medicaid. And then upon his death, the trust then went out to the next level of beneficiaries, which were in that first document saying that it was going to trigger into a supplemental needs trust, which in this case were the children of the younger Medicaid beneficiary. Another trust that we commonly work on is called a credit shelter or a bypass trust. These are trusts that are used when there are two spouses and we are trying to create estate tax protection at the death of the second spouse. If I have $4 million and my spouse has $4 million, when I die, if everything passed directly to my spouse, there would be no estate tax because I have less than the amounts. New York State being 5.85 million, the federal government being over 11 million. My 4 million is underneath both. When I pass to anyone, there would be no estate tax. When it passes to a spouse, even if it was over the exemption amount, my spouse wouldn't pay estate taxes because there's a marital deduction. The problem becomes that if my 4 million goes to my spouse is not paying taxes because we are married. Upon my spouse's death, they now have 8 million or whatever it's grown to be. So now my spouse has a taxable estate in New York because they're over the 5.85 million. So if in my documents it says that a share of my estate goes into a credit shelter trust or a bypass trust, it will use my exemption. Even though my spouse didn't need it, it will use my exemption. It will not, that amount will not be part of my spouse's estate. And then when my spouse dies, only the assets in my spouse's estate are going to be taxed. And then if it passes on to our children, for example, there's not going to be an estate tax because my spouse didn't die with 8 million. They died with 4 million plus the trust that had been taxed at my death. And that's what a credit shelter or a bypass trust is. It's in order to use up my exemption as the first to die spouse so that the second to die spouse doesn't end up passing on an estate with a large estate tax or any estate tax to the next set of beneficiaries, the children or cousins, whatever it may be. There are also family trusts that we create. So let's talk, for example, about if I have, let's say I was previously married and I have 3 children from a prior marriage. Now I have a new spouse. We've been married for 40 years. And upon my death, if my spouse is still living, I would want my spouse to be cared for. I want to make sure my spouse has everything they need. But I also want to make sure that when my spouse then subsequently dies, that everything's not going to just go to their children or their nieces and nephews or whoever it is that they're leaving things to, and leave my 3 kids from my prior marriage out. In that case, I may be passing assets to my spouse in a family trust or in a mixture of a family trust and a bypass trust, depending on the tax issues, so that my spouse can have the benefit of that money. I can decide if I want my spouse to be the trustee or if I want them to be co-trustee with one of my children or just one of my children to take care of them. And that's going to depend on your personal situation. But make sure that my spouse is cared for their lifetime, but then also make sure that whatever's left in that trust when my spouse dies is going to go back to my individual children, to the ones from my first marriage, to make sure that they have what I wanted to leave for them. I'm going to stop now because I see we have a question. So I'm going to take the question before I move on. Liz, do you want to read out the question to the group?
Sure. In an investment account, your only adult child is the beneficiary. If she was to predecease me, her minor children, not her husband, are the secondary beneficiaries. Would it be recommended to have a trust for them?
That's a great question. Short answer, yes. You don't want to be leaving assets to minor children because minors can't open an account and hold the assets. And even if there is a parent still alive, it's confusing, but a parent is the legal guardian over a child's personal needs, so their healthcare decisions, physical custody, but a parent is not the legal guardian over a child's assets until the court appoints them as such, even if they're the birth parent, or until the child turns 18, then the child controls it on their own. So if you have minors that may end up as beneficiaries, what you're going to want to do is create a trust for the benefit of the minors in your documents. And then in this person's case, it would say on the investment account, one, you could make a will that says, upon my death, there's a trust created for my daughter for all of the reasons I said of creditor protection, avoid estate taxes. The assets from the investment account, the named beneficiary could be the trust for the benefit of my daughter. And then once it will say in the trust, in my will, that if my daughter predeceases me, or if my daughter dies after me, but the assets have gone into the trust, that then that trust will move to be a trust for the benefit of my children, if they're minors or they're not minors. And that would be the cleanest way to do it, to make sure that those children get the assets in a trust. And you can say specifically in the document who would manage the funds for the children. It may be their parent, and I think in that case it was a husband, so it might be the father of the children who is named in the grandparents' documents as the trustee if their child or the daughter should pass first. Or you may not like the father of the children, or you may not trust, you may like him very much, but not trust how he handles money, and you might want to name another person to handle those assets for the children, and that should be in the document.
Thank you. Next question. What are the federal and New York State tax rates on estates?
Yes. So I'm not going to have the numbers exactly right, but in New York State, if you die with less than $5.85 million to your name, there are no estate taxes. The problem in New York is that if you have over the exemption amount, then there's what we call a cliff. And they call it a cliff because of this. There's no tax all the way up to 5.85. And when you hit the top, you tip over the cliff and you fall down and you're taxed back from $1 in New York. So that's the New York State. The exact percentage of what the taxes are going to be is a sliding scale based on how far over the cliff you are. I think the highest is at 16% in New York State. For the federal government, the current number is 11.58 million. It is set to go back to what New York is in 2026. And so in 2026, it will be the 5 million index for inflation, which right now is 5.85. But until that point, it's 11.58 million right now. And if you go over, you're taxed on the overage, but it's a much higher percentage. And it's somewhere, I don't know the exact number, and there was the tax law changed it, so I don't want to say that number, but somewhere between 35 and 40%, I believe. But don't quote me on that, I have to look it up.
I don't see any other questions.
Okay, great. So I'm going to keep going with a few things. So going back to when we were talking about the trust for the benefit of the spouse, for example, you could say everything goes to my spouse in a trust, but if my spouse remarries, they can no longer receive principal. They can no longer receive anything beyond income from the trust. Or if my spouse remarries, they need to sign a prenuptial agreement that protects the trust assets for my children to make sure that the money doesn't go to the new spouse or to the new spouse's children or new children. And some spouses want to put that in their documents. Again, it's going to be very fact specific and very person specific based on their relationships and the sensibilities of the individual who's writing up the document. If you leave everything to your spouse in a trust, so if I say I give 100% of my assets to my spouse, but my spouse can only receive the income and can receive the greater of $5,000 or 5% annually of trust principal, your spouse, assuming they didn't sign away this right in a prenup or something, or some other document with you, your spouse has the right to say, I don't want it all in trust. I want money and I want it outright in a bank account that I'm in control of, and I don't want your terms. And so I am going to reject the trust that you've left me, and I'm going to elect what we call the right of election, which is the spouse saying, you can take your 100% and your trust, I don't want it, I want 1/3 outright. And a spouse has the right to force 1/3 out of the estate outright to them without any of the terms of a trust. And that is why people say, you may have heard people say, you can't disinherit your spouse in New York. That's what you're talking about. Unless your spouse has waived that right, they can assert it and they can force 1/3 of the estate, even if the spouse is totally left out of the documents and nothing is left to the spouse, they can force 1/3 because that is a spousal right in New York State. I think we can take the next question, Liz.
Sure. I have a joint bank account with my daughter. Does she get all of the account on my death, even though my will divides equally between my 3 children?
So another good question. So yes, if it is a true joint bank account that's joint with rights of survivorship, then yes, it will go to the joint owner. So it's very important that you make sure that your will and your wishes are in concert with how you write up your bank, how you hold your bank accounts. When I sit down with a client, one of the first things, I'd say one of the first 3 things that I'm going to talk about are, what are your assets and how are they titled? It's very important because, for example, if there are 2 spouses that own a property together, an apartment or a home, the question is, in what way do you own it? Forget 2 spouses, any 2 people who own property together. You could own it joint with the right of survivorship, meaning that the person who survives the other is 100% owner. Or you could own it what we call tenants in common, which means if 2 people, let's say my sister and I own a property together, as tenants in common, upon my death, my half of that property will pass pursuant to my will. So I could leave it to whoever I want. If it's not joint with registered survivorship, it won't automatically go to her. So if you do own a property as tenants in common, you're going to want to be clear, and that's often that is the default on documents if nothing is written in. If two people who are spouses own a property, and this is all the current law, but people who own property from many years ago when it was originally purchased should make sure that this was the law when they purchased it. But two married people who own a property together own it by what we call tenancy by the entirety, which is similar to and basically the same for death purposes as joint with registered survivorship. So the surviving spouse would own it 100% when the first person died. So this is all very important to make sure that what is written in your documents, in your will, is going to correspond with what your wishes are and how your accounts are held.
Okay, next question. For someone with perhaps $10 million in assets, what is typically involved in creating a will, hours and costs?
Okay, so hours is, I don't think I can answer that question. I have had people with $30 million who are very clear on what they want. They tell me exactly what they want. We draft it up. We send them a draft. They're happy with the draft. They sign it very quick. I've had people with $20,000 who hem and haw over it because they don't know who to leave things to, and they're not sure how they want to do it, and they don't know who they trust as executor, and it's taken 1.5 years to get it done. So we obviously prefer the former rather than the latter, because I don't think it generally, if people are doing a document like a will, we want them to have it in place to protect the people they're leaving things to. And so it's important to get it done in a relatively quick period of time, even if down the line you tweak it so that you have something in place. So time is a hard thing to cover. Cost, I can give a range of costs, I think is fair, but again, it's going to depend. For example, I was speaking today about how someone could have a pet trust. They could have a common pot trust for the minor children that then feeds into descendants trust. And if somebody's disabled, there could be a supplemental needs trust. So a will could be anywhere from just a few pages to 40 or 50 pages long, depending on how complicated it is. Somebody with $10 million in assets, as the question asked, is an especially interesting case on estate planning ends, because you have a New York State taxable estate with that cliff, but you don't have a federally taxable estate, at least not if you die right now. But that person could die after 2025 is over, in which case there would then be likely be a federal estate tax too. All that to say, it's a very large range of what it could cost. So a will could be anywhere from, and this is all give and take on either side, anywhere from $1,200 to $3,500 if you're talking about really putting in a lot of complicated trusts and tax planning and things like that.
Okay, I apologize. I am a widow. Create a will now. I believe that was meant for a question.
I think they clarified. If I remarry in the future, do I need to create a new will? Okay. So what I would say to that is that we tell people that you should create your will now, yes. You should have a will. And if you're a widow and you haven't redone your documents since the passing of your spouse, then yes, I would suggest doing a will now. That being said, I also tell people that they should review their estate planning documents every 5 years with their attorney, or sooner if there's a major life event. Remarrying falls into the category of major life event: death of a spouse, divorce, birth of additional grandchildren, birth of a child, death of a child, retiring. These are all big life events that might change how you choose to do your estate planning and would warrant a review of your documents.
Thank you. Can you have a will without a trust?
Yes, that is going to fall in the lower cost bracket of what I was describing. Yes, you certainly can. There are people who have a will that says, upon my death, everything goes 100% to my daughter outright, no trust, no protections. And a lot of people choose to do that. It's going to depend on the individual situation. It's going to depend on the assets and who they're leaving it to.
Thank you. I don't have any additional questions.
Great. Well, I'm done with the topics that I was going to go through today. Again, you know, I say every time we do one of these that everybody's situation is different. So it really requires you to sit down with your attorney and go through exactly what your family situation is, what type of assets you have, and what the best way to follow your wishes for after death are. And some of these things that I pointed out today are just things to get you thinking, but it really doesn't take the place at all of a one-on-one situation where you can figure out what's best for you and for your beneficiaries. We can hold on for a minute or so and just see if any last questions come in. But otherwise, I think that's, oh, here we go.
Do you also do prenuptial agreements?
Our firm does not do prenuptial agreements, but we have firms that we regularly have worked with or have worked with in the past that we'd be happy to make a referral if somebody is looking to do a prenuptial agreement. I do think, and I've done webinars along with divorce attorneys just a few months ago with a divorce attorney that I'm familiar with in the city, that it is important, especially if you have a prenuptial agreement or a divorce agreement that, or a separation agreement that are talking about forced estate planning. So, you know, we're getting married and you have to have a will that has certain provisions, or we're getting divorced and you have to have a will with certain provisions, that an estate planning attorney and a matrimonial attorney should be working together on those documents.
That particular person, if you wanted to email us at info@Berner Law, we can give you that referral. The next question is, what are the options for running trusts and annual cost of maintaining a trust?
So it's going to depend on a lot of things. I mean, if the trust is managed and administered and the trustee of the trust is a family member, unless you're giving that family member annual commissions, the ongoing annual costs of maintaining a trust, there are none. Depending on the type of trust it is and how it's written, it may have tax consequences. It may require an income tax return to be filed, so that could be a cost. And it may actually require the trust to pay taxes. So again, it's all going to depend on what type of trust you get and what it is. But in terms of maintaining the trust, you either would be the trustee yourself, you could name someone else's trustee, or in certain circumstances, you can name an institutional trustee like a bank or a corporate trustee, and they would have annual fees that they would impose based on their rules.
Thank you. Are you setting up appointments in person yet?
At this point in time, we are seeing people in person by appointment only at our West Hampton Beach and East Setauket locations. Our Manhattan location hasn't opened up to in-person yet, but since the beginning of March, we are seeing clients via Zoom, as well as telephone calls, whatever works for people across all three areas.
Thank you. If I have one daughter and set up a trust for her, can she be the only trustee?
She can be the only trustee. I would just want to make sure that the purposes or the reason why you created the trust weren't thwarted by the fact that she was her own trustee. There's nothing that says somebody can't be their own trustee.
Thank you. And that looks like it's it for the questions. If you had anything else, Britt?
No, I think that's it. I hope everybody has a happy 4th of July and continues to stay safe and healthy, and we'll talk soon.